10 o'clock and we're going on to the record. Good morning. My name is James McClymans. I'm the Chief Administrative Law Judge with the Office of Hearings and Mediation Services of the New York State Department of Environmental Conservation and the presiding Administrative Law Judge for the adjudicatory hearings being conducted on the application of Finger Lakes LPG Storage, LLC, for permits to construct and operate a new underground liquefied petroleum gas, or LPG, storage facility proposed to be located in the town of Reading, Schuyler County. This morning, we are conducting an issues conference pursuant to Section 624.4B of Title VI of the official compilation of codes, rules, and regulations of the state of New York, or 6 NYCRR. For the record, this issues conference is being held on Thursday, February 12th, 2015, at the Holiday Inn Express, 2666 Corning Road, Horseheads, New York. I would now like to take appearances of counsel, starting with department staff.
Your Honor, appearing for department counsel, Lisa Schwartz, Assistant Regional Attorney, Jen Maglianti, and Larry Weintraub with the Office of General Counsel in Central Office. Do you want us to introduce the supporting program staff? I have quite a few.
Yes, please do.
Okay. From our Division of Minerals Resources, Peter Briggs, Tom Knoll, Eric Rodriguez, Linda Colart, Paul Giacchetti. From our Division of Environmental Permits, Scott Shealy, Dave Bimber. Also assisting from the Department of the Division of Environmental Permits, John Clancy and Kevin Balduzzi. From our Division of Air Resources, Tom Wickerham. Our Regional Engineer, Frank Ricotta. From our Division of Materials Management, Scott Bodie, Mark Damagala, Bob Panaugh. From our Division of Water, Scott Rodebach. Also with the Office of General Counsel, the Regional Attorney is present, Dennis Harkowitz. With our Communications Office, Linda Vera and Tom Malin. Where they are in the room. And that's what we have here for the department staff.
Thank you. And for applicant Finger Lakes LPG Storage.
Kevin Bernstein, Von Seneca King for the applicant. We also have a number of experts in the reserve seats, and we'll just introduce them at the appropriate time as the proposed issues come up.
Robert Alessi, DLA Piper, also for the applicant. Thank you.
Thank you.
Brad Baker with the applicant.
I'm sorry, Fred Baker?
Brad Baker
Brad
with
Baker.
the applicant.
Thank you. And for full party status petitioner Gas-Free Seneca.
And I'm Deborah Goldberg of Earth Justice. I'm here with my colleague Lindy Naismith and with Will Burns of the Burns Law Firm, representing Gas-Free Seneca. And we will also introduce them. Oh, I'm sorry, I'd also like to introduce Katie Thompson, our litigation assistant.
And for full party status petitioner Seneca Lake Pure Waters Association.
Rachel Piper, and I'm here with our experts, Dr. Roy Vaughn, Dr. William Neto, we have consultant Richard Young, Bill Hank, and LEC, and Priscilla from Crestwood for
And for full party petitioner Seneca Lakes Communities.
Good morning, Your Honor. I'm Kate Sinden with the Natural Resources Defense Council, and I'm accompanied by my colleagues Dan, Rochelle, and John Boyce.
Should we list all of your clients at this point, or is
We could do that. Is that
Why don't we go
okay?
ahead?
Let's see if I can do this by memory while we look for.
Well, I can do it.
Okay, that would be
So
great.
far as I
Your Honor.
understand,
Appreciate that.
you're representing Seneca County, Yates County, Town of Fayette, Town of Geneva, Town of Ithaca, Town of Romulus, Town of Starkey, Town of Ulysses, Town of Waterloo, City of Geneva, Village of Watkins Glen, and the Village of Waterloo.
That's correct, John.
And for amicus status petitioner, Finger Lakes Wine Business Coalition.
Yes, Your Honor. May Ford, Helen Barone, with my partner John Barone for the Finger Lakes Wine Businesses Coalition.
And for amicus status petitioners, Schuyler County legislators Van A. Harp and Michael L. Lassell.
I'm Michael Lassell, and this is my fellow legislator, Van Hope.
And for amicus status petitioner, National Propane Gas Association.
Good morning, Your Honor. Jeffrey Petrash for National Propane Gas.
And for amicus status petitioners, New York Propane Gas Association and Propane Gas Association of New England.
Good morning, Your Honor. Matthew Grayson from Freeman.
And do we have an appearance for the amicus status petitioner, United Steelworkers International Union? All right.
Be here tomorrow, as far as I understand, but they're, I need to come up on this calendar.
Very good, thank you. And October 22nd, 2014, notice of deadline for petitions for party status and issues conference was published in the October 29, 2014 edition of the Department's Environmental Notice Bulletin. A copy of the ENB notice has been marked as OHMS document number 2011-66576-00010. In addition, Department Staff Counsel has provided me with an affidavit of publication of the notice on October 29, 2014 in the Watkins Glen Review and Express. The affidavit of publication is marked OHMS document number 11. Pursuant to 6 NYCRR 624.4B, the notice scheduled this pre-adjudicatory hearing issues conference for today, Thursday, February 12, 2015, at 10 a.m. at this location. The notice also originally established Wednesday, December 10, 2014 as the deadline for the filing of petitions for party status. On November 18, 2014, a notice extension of deadline for filing petitions for party status was issued, extending the deadline to Friday, January 16, 2015. The notice extension was published in the ENB on November 19, 2014, and in the Village of Watkins Glen Review and Express on November 26, 2014. The following 9 party status petitions have been filed with the Department's Office of Hearings and Mediation Services. For full party status, I have the petitions of Gas Free Seneca, Seneca Lake Pure Waters Association, and the Seneca Lake Communities. I also have the amicus party status petitions of the Finger Lakes Wine Business Coalition, Schuyler County legislators Van A. Harp and Michael L. Lassell, National Propane Gas Association, the New York LP Gas Association, Inc., Propane Gas Association of New England, and the United Steelworkers International Union. The purpose of this issues conference this morning is, 1, to hear argument on whether party status should be granted to any petitioner. 2, to narrow or resolve disputed issues of fact without resort to taking testimony. 3, to hear argument on whether disputed issues of fact that are not resolved meet the standards for adjudication set forth in 6 NYCRR 624.4C, and 4, determine whether legal issues exist whose resolution is not dependent on facts that are in substantial dispute, and if so, to hear argument on the merits of those issues. An issues conference is not a hearing at which testimony and evidence are presented. If it is determined by myself and the Commissioner that factual issues require adjudication in this proceeding, an adjudicatory hearing will be scheduled at a later date. The identification of issues for adjudication, if any, will be made in a post-issues conference issues ruling by myself and in an interim decision of the Commissioner if any appeals are taken from my ruling. Some of the issues raised by the party status petitioners may involve discussion of documents and materials applicant Finger Lakes LPG storage claims are confidential. The grounds for confidentiality include trade secret, confidential business information, and critical infrastructure information. During argument on those issues, attendance in this hearing room will be limited to representatives of applicant and department staff and those individuals subject to a confidentiality agreement and order issued in this proceeding. Any persons, including the press and the public, who have not executed the confidentiality agreement and order will be asked to leave the hearing room at that time. Presently, we plan on closing the hearing room at midday today for the discussion of confidential issues. We will resume the public portion of the issues conference tomorrow morning at 9 a.m. Members of the public, the press, and other interested individuals that wish to observe the remaining public portions of the conference after we close the hearing room today may return tomorrow morning. So with that, I would like to proceed, but first I have a bit of housekeeping to do. Yesterday I transmitted to the parties a proposed schedule for the argument today. I did my best to try to allot time fairly to everyone based on the issues that were presented in the petitions for party status. After I sent that around, I received, did everyone get a copy of this? Just want to make sure before we go any further. Okay. After I sent it around, I received an email from Ms. Treichler asking whether or not she could be heard on the question of water quality during the confidential session this afternoon. So I guess we can do that. How much time would you like to have on the issue?
I guess the same as the other parties,
A full 20 minutes?
20 minutes. Well, maybe I only need 10. I might only need 10.
Then I would need to add time to the response by applicant and by staff. So if we let's see.
Your Honor, the Seneca Lake communities would be willing to cede 10 minutes of our time to Ms. Treichler, and that would keep us on schedule.
All right, very good. We want to do that. All right, so we'll 10 minutes for Seneca Lake communities and then 10 minutes for Seneca Lake's Pure Waters. So do we need to add any time then to the applicant or staff's time on that?
Your Honor, we would just like to, we don't think so, but depending upon how new it may be, we may ask for some, but we don't anticipate any of this.
All right.
And then as I look at my notes on their petition and their reports, have integrity on water quality.
That was my impression as well, but
So, I mean, as long as they're not bringing in anything new that otherwise could have been put in their petition for the status.
It's issues that were raised by our petition.
all right, fair enough. I mean, I could schedule at this point, we'll add another 5 minutes to applicants. Nobody should feel compelled to use the full time.
Understood.
Should I add another 5 minutes to staff too, just in case?
Just in case.
So that would get us, if all goes according to plan, we'd be done at 4:30 this afternoon. See how that goes. All right, so what I'm going to do here, since I don't have a white light and a red light, I'm going to set a timer for 1 minute less than the allotted time. When it goes off, that means you got 1 minute left, all right? So we'll see how that works. All right, is there any other preliminary matters that you would like to raise at this point before we start with the argument? Is everybody fine with the order of presentation that I've laid out? Or anybody else that would not like to go first? You're going to go first? All right. All right, so let's start with on the issue of community character, Representative Gas-Free Seneca. Oh, and by the way, would everybody please turn off their cell phones or put it in airplane mode?
Well, I can sort of see you.
Yeah. Is it?
Let me see if I
Can
can
these
lower these a
microphones
little
be
bit.
pushed down? Oh, let's go off the record for a moment. Can these microphones be pushed down so that
Yeah, they should tell.
I can see?
Yeah, they all tell.
Would you guys like to do it?
Certainly.
Either that will have to give me a diet.
Yeah, this one I think is okay, if you can hear. I've been known to stand on binders if necessary.
We got a lot of papers, so you
Yes.
could use those.
Yeah.
Is that good?
Thanks.
All right.
Thank you very much. As I mentioned earlier, we are here representing Gas-Free Seneca, which is a coalition of individuals and now 315 businesses. I have a list of those businesses if you're interested, which I can hand up to you at a later time. Many of those members are here today. They were instructed that T-shirts were appropriate for rallies, but not for judicial proceedings, so they're a little bit less visible. But I assure you that they're here. Here to address, obviously, the first issue and one that's of greatest concern, and that is community character. Community character is both a substantive and significant issue that should be adjudicated because there's absolutely no analysis whatsoever of impact on community character. Is this on? Okay, can you hear me now? Okay. Your Honor, I'd like to reserve 2 minutes, so I'm not sure if you're at 9 minutes or 7 minutes. I'm sorry. And thank you. The issue of community character is a substantive and significant issue because there is sufficient doubt about the applicant's ability to meet the requirements of the State Environmental Quality Review Act such that a reasonable person would require further inquiry into that issue. That's true because there's no discussion whatsoever of community character in the application or the draft environmental impact statement. The project will have significant adverse community characters for which there's no proposed mitigation, and therefore the project is not the alternative that avoids or mitigates the impacts to the maximum extent practicable. So the DEC cannot make the findings with the 2 requisite certifications. It's also a significant issue because these significant adverse community character impacts should result in the denial of the permit. Even if the permit is not denied, the community character impacts should result in a major modification of the project. And at the very least, those impacts should result in the imposition of significant additional permit conditions, additional study, and public disclosure of the results for visual impacts, noise, socioeconomic impacts, and other components of the community character analysis. Because there was no community character analysis in the DSEIS or any of the application measures, Dr. Harvey Flad, a professional geographer, formerly of Vassar with 45 years experience, did his own cultural landscape study to determine the existing character of the Seneca Lake community against which project impacts could be measured. As you know, Your Honor, community character is a separately listed element of environmental concern under SECRET. It is one of the independently identified significance conditions, and under Chinese staff, it must be evaluated separately, even if there is no other physical impact on the environment. The applicant mocks the cultural landscape study because, evidently, is unfamiliar with what geographers do or the methodologies they use, but DEC has endorsed them. In the most visible revised draft supplemental EIS, generic EIS, on the hydraulic fracturing program, the community character analysis provides the following definition. A community's character is defined by a combination of natural physical features, history, demographics, and socioeconomics, and culture, citing Robinson 2005. Key attributes or features used to define community character generally include local natural features and land uses, local history and oral traditions, social practices and festivals, unique local restaurants and cuisine, and local arts. In addition, SECRA acknowledges community character as a component of the environment, including existing patterns of population concentration, distribution, or growth, and existing community or neighborhood character. Further, they say, a sense of place also is central to community character or identity. Sense of place can be described as those tangible and intangible characteristics which, over a period of time, have given a place its distinctiveness, identity, and authenticity. This is Robinson 2005 again, and that is an article that was delivered at a seminar entitled Cultural Landscapes in the 21st Century. This approach is consistent with controlling precedent in Chinese staff, a New York Court of Appeals decision which is clearly binding on the commissioner's decisions, recognizing that community character is a distinct category, and it is also consistent with the administrative decisions cited by the petitioner, the applicant, that community character is intertwined with other areas of environmental concern. Having developed a clear account of the Seneca Lake community character based on an uncontested cultural landscape analysis, Dr. Flad can explain why the project's visual, noise, and economic impacts will significantly impair community character. His approach incorporates all of those elements and more. It is inherently a multidisciplinary approach, but it is not a reductive approach. It does not assume that community character can be reduced without loss to the various components with which it's intertwined. Instead, community character emerges from the relationship of the people in a place to all of those elements. As the 2010 Seeker Handbook recognizes, courts' decisions have held that impacts on community character must be considered in making determinations of significance, even if there are no other impacts on the physical environment. Moreover, the Seeker Handbook recognizes community character relates not only to the built and natural environments of a community, but also to how people function within and perceive that community. The perceptions of the community are key to understanding community character, and the courts have recognized that those perceptions are best expressed through zoning and land use and other public documents, including such things as economic development programs, historic designations, in this case, the American Viticultural Area designations, the Scenic Byway designation, all of which are expressions of the citizens' own vision for themselves. A vision that is mocked by the client, but that is recognized clearly in the branding that has been used by the businesses that are represented here at the conference.
Let me ask you one thing. If we adjudicate community character as you propose, what is your proposal? Would you basically use the testimony of Mr. Flad to develop the record on what the character in this community is, or is your position that doesn't need to be done? The community character was not addressed, so therefore the permit has to be denied at this point based on the EIS as it currently exists.
But I would argue as a matter of law that it ought to be denied. I would also argue that we should have a record on the issue, that he is prepared to testify on that. And we also have the assistance of Dr. Susan Christofferson, who's done the economic analysis. She's not being proposed as a separate issue, but rather socioeconomics is a key aspect of community character, so she would be prepared to testify as well. And they would also testify about the significant impacts, obviously. An alternative would be to direct the applicant and DEC to consider this and develop the record, and then revise the draft supplemental EIS and put it out for public comment so everybody could see it and respond to it, and then revisit the issue at that time.
Can I take the materials that you have submitted with your petition and treat that as a supplementation of the secret record in this matter? Would that be sufficient in order to provide the decision maker with characterization of community character for making secret findings?
It certainly should be adopted as a comment on the DSES, if nothing else, under the regulations. I don't think it's sufficient, Your Honor. We had a very short period of time in which to pull these things together. There's more elaboration that could be brought in order to fully develop the trends that are developing and to address some of the issues that have been proposed by the applicant that contest the analysis that we don't have time to do, and obviously we haven't had an opportunity to do yet today. We also obviously could do some post-issues conference briefing on this issue to develop the record further. But I think an adjudication is appropriate in this case since it is a highly fact-dependent analysis with a developed methodology that has been ignored by both the applicant and DC in this case.
All right, thank you. So I have that you reserve 2 minutes.
Correct.
Ms. Seidel.
My colleague, Mr. Rochelle, is going
Are you reserving any time for rebuttal?
No. Morning, Your Honor. My name is Dan Rochelle. I'm representing the Seneca Lake Communities. It's a collection of 12 municipalities in the Seneca Lake region, and is already detailed by Mrs. Goldberg on behalf of Gas Free Seneca. The draft environmental impact statement for applicant's proposed LPG storage facility raises a significant and substantial issue for adjudication because it wholly ignores significant potential community character impacts that will affect the Finger Lakes region at large, including the Seneca Lake communities. These impacts are not speculative or purely psychological, but are rooted in fundamental and material conflict with the character and development goals of the communities of the Finger Lakes as expressed in their comprehensive planning documents, both on a regional and individual municipal level. The secret regulations are clear that the creation of a material conflict with a community's current plans or goals as officially approved or adopted is a significant environmental impact that must be considered as part of the environmental review process. This is supported by a well-known secret case law such as Chinese staff in Village of Chestnut Ridge, which state that the impact of a project may have an existing community character with or without separate impact on the physical environment is a relevant concern in the environmental analysis, and that substantial development in an adjoining municipality can have significant detrimental impacts on the character of that community, specifically on the ability of the affected municipality to determine its community character through planning. This principle is also bolstered by the cases cited by applicant in its response. I'm referring to the Crossroads Ventures case and St. Lawrence Cement cases, which state specifically that the department, to a large extent, relies on local land use plans as the standard for community character, and adopted local plans are afforded deference in ascertaining whether a project is consistent with community character. In the present case, it is clear that the planning documents of the Seneca Lake region reflect a strong desire to protect their central and defining asset, Seneca Lake, and their identity as an emerging center for tourism, viticulture, and agribusiness. This is apparent in regional planning documents such as the Seneca Lake Watershed Management Plan, the Seneca County Environmental Conservation Plan, and also in the planning documents of individual municipalities such as the Comprehensive Plan for the Village of Watkins Glen and the Master Plan for the City of Geneva and its local waterfront management plan. For example, in the Seneca Lake Waterfront Management Plan, Seneca Lake, it describes Seneca Lake as key to tourism and a primary economic driver of the region. And in the Watkins Glen Comprehensive Plan also mentions that Seneca Lake is a strength of the region and that a weakness of a region is industry on the waterfront, and specifically that a threat to its own land use planning goals is this particular LPG facility. Even the Schuyler County Comprehensive Plan recognizes that Seneca Lake is a defining feature of the county, and that the county's natural environment is its biggest asset that it is important to protect in the best possible way. The importance of Seneca Lake and the threat that heavy industry poses to agricultural, rural, and small-town character of the region is also expressed in other efforts and legislative actions taken by the municipalities in the region. For example, after investing substantial time, effort, and money in revitalizing its own waterfront, pursuant to its waterfront management plan, the city of Geneva, along with another municipalities, opposed the construction of a rail spur in Seneca Fall that would have serviced a landfill there, because multiple trash trains running to and from the landfill would have run directly through the Geneva waterfront. Additionally, nearly every municipality on the western side of Seneca Lake at one point or another passed a ban or moratoria on high-volume hydraulic fracturing, and this includes, in some cases, a prohibition on the storage of gas. But even more so than trash trains, the proposed facility, with ambitions of serving the Northeast propane market by making 2.1 million barrels of LPG available through large-scale truck, rail, and pipeline access, will run through the heart of the Seneca Lake region, directly conflicts with these planning goals in three major respects. One, the fact that this facility is a heavy industrial use. Two, the fact that it is located in close proximity to Seneca Lake. And three, as will be discussed later today, the fact that this is a high-risk industrial use with the potential for a catastrophic incident that could define and stigmatize the region for years to come and displace desired and compatible sustainable development such as agribusiness and viticulture. At an adjudicatory hearing, the Seneca Lake communities will proffer the comprehensive planning documents of municipalities within the region, as well as regional planning documents, and the testimony of local planning experts that will corroborate the fact that this facility is plainly incompatible with these comprehensive planning goals. Overall, the Seneca Lake communities will show that given the heavy industrial nature of this facility, the high-risk nature of the facility, and SECRA's clear requirements regarding the consideration of community planning goals as formally expressed in planning documents, make that the whole-scale omission of the effect of this facility on community character in the region, an inexcusable omission and a violation of SECRA.
The town of Reading doesn't have any plan, is that correct?
That's correct. However, according to a well-known SECRA precedent, including the village, which includes the Village of Chestnut Ridge case, the impacts of the planning decisions in one municipality can have significant community character impacts on adjoining municipalities, in this case, probably most pronounced in Watkins Glen. And I'll note that in the Village of Chestnut Ridge case, what was at issue there was a local law allowing adult student housing next to the village border. This is something that is much more noxious as a use, and not to mention that it requires the transportation of hazardous materials through all of the adjoining municipalities.
Do you have authority that would support looking as far afield as Geneva, which I understand is at the top of Lake Seneca and several miles away from the proposed facility?
We think that given the nature of this facility and that it requires the transportation of large quantities of hazardous materials through the region, that would be appropriate, particularly given that at some point this facility may expand in the future. I mean, it already envisions the transportation of large amounts of this material, and it's our understanding that it could expand by fivefold in the future.
I guess my question is, do you have any case law that would support looking at regionally as opposed to in the locality of the facility?
We would probably cite Village of Chestnut Ridge.
Village of Chestnut Ridge, all right. And I guess I'll ask you the same question that I asked Ms. Goldberg. Can I simply accept the plans that you've submitted with your petition, and is that sufficient to complete the secret record on the issue?
No, we would like to supplement the record with additional planning documents and also the testimony of local planning experts.
All right. I have no further questions.
All right, thank you very much.
The Finger Lakes Wine Business Coalition. Are you reserving any time?
Yes, please, Your Honor. We'd like to reserve 2 minutes for rebuttal.
Very good.
Thank you. I'm Maeve Tour. I'm here on behalf of the Finger Lakes Wine Business Coalition. We are, as you know, seeking amicus status. We're seeking amicus status as it is defined as a friend of the court. We think that the Finger Lakes Wine Business Coalition has a unique voice and opportunity to present information to you, Your Honor, in considering this application, particularly on the issue of community character. The mission of the Finger Lakes Wine Business Coalition is to lead upstate economic development through wine-driven agritourism and sustainable businesses, practices, unifying wineries, vineyards, local food producers, and creatives who are the stewards of the Finger Lakes wine country. The Finger Lakes Wine Business Coalition has over 100 members representing these various businesses and interests. There are over 140 wineries in and around the Finger Lakes region. We've provided a map that shows you the density and spread of those wineries as Exhibit B to the petition. We think that the voice that the Business Coalition has to offer and the perspective of the wineries will help you in evaluating the community character impacts of this project. As part of 6 New York CRR 624-5B, we're required to show you the environmental interest that we have in the proceeding that we think relates to the significant potential environmental impacts to the local, regional, statewide, national, and global perspectives that our entity provides. We believe that we can provide you perspective on the character of Seneca Lake and the Finger Lakes wine country, the social and economic vitality and base of the area, that it overshadows and stigmatizes the region to allow a facility of this nature to be brought into the community, that it can lead to other large-scale industrial projects and create a potential for environmental catastrophe and ultimately transform the Finger Lakes wine country from the unique configuration of glacier-formed lakes, rolling hillsides, terraced vineyards, bucolic viewsheds, and historic villages back to an industrial past of environmental degradation and economic blight. The failure to assess this impact is irretrievable and will be felt both throughout the Finger Lakes wine country and the tourism industry of the state. We have provided you the affidavits of various members of the coalition in order to give you an idea of what the impact is on this community. This is not, as alleged by the applicant, a pure economic interest. It is the very character of the Seneca Lake wine country region. We've provided you the affidavit of Bruce Murray from Boundary Breaks Winery. He speaks to the symbiotic regionalism of the Finger Lakes wine industry, that there is an entire industry that grows not as one winery or one industry, but as a community together, working together to bring recognition to this industry within the state and within the rest of the country. He speaks to the role of Watkins Glen, the very place where this facility will be located within that industry, within the Finger Lakes wine region. We have the affidavit of Christina Hazlitt of Sawmill Creek. She speaks to the historic nature of this industry, stretching back to the 1860s. This is 7 generations of a farm family community that have worked to develop their winery and their industry. It's a threat to their way of life with no offsetting benefits. Justin Boyette has also provided an affidavit from the Hector Wine Company and Forge Cellars. He speaks to the growing international participation in the region that's threatened by this disregard of the environment. We've provided a letter from French vintner Louis Barol. He is actually looking to invest in the Finger Lakes wine country to link it to the international wine community. However, he speaks to the wine industry and vintners as a way of life that's dependent upon the very perception of this area. Lou Damiani of Damiani Wine Cellars has provided an affidavit. He speaks how this will alter the viewshed of his winery, and he speaks to the regional success of the wineries themselves and their interrelationship among the very community that they grow from on Seneca Lake and the Finger Lakes wine region as an entire community that works together. Connor Evans of Cashel Brish Winery, which is located in Watkins Glen, he notes that Watkins Glen is the very gateway to this area of the Finger Lakes wine region, and that tourism is drawn through those gateways, that this facility's location will impact the character of the Watkins Glen community and the Finger Lakes wine region. William Owaleen of Oneida and Eagle Crest Vineyards also speaks to the history of the Finger Lakes wine region. They've been making sacramental wine since 1872 at the Oneida Vineyards, and it also is an example of the regional symbiosis. He draws grapes from all over the Seneca Lake region for use at his vineyard. Finally, John Wagner of Wagner Brewing, Winery and Vineyards, has again speaking to generational devotion, that this is a diversification of the region that brings unique community benefits, and that this project will stigmatize the region in a way that we cannot avoid. Scott Signori of Stonecat Cafe brings a unique perspective of a restaurant owner. He has developed an artisanal food and beverage industry that again is dependent on the Finger Lakes wine region. He sits on the Seneca Lake Wine Trail. The community character is very important to his business and to the growth of this industry. We would submit, Your Honor, that failure to look at the community character that the Finger Lakes wine businesses present is a big gap in the record here, and that our voice is very important to allowing you to give full and complete consideration to that very important aspect of the impact of this project.
So let me ask you, you're petitioning for amicus status, and under our regulations, an amicus party would be entitled to file briefs and make argument on legal issues, but you're saying you want to present information. So how would you do that as an amicus?
We think that the information that we present is part of the legal argument here. The applicant has disputed community character as an appropriate consideration separate and apart from the various issues that are raised. We think that the information that we present goes to that very legal determination of what is community character here and what you should be considering in evaluating community character.
Aren't you trying to establish a separate factual record of what the community character is? I mean,
No, I think what we're trying to do here is we will be, obviously the other parties are speaking to the issue of community character. We're looking to give you a full and informed viewpoint as to what that issue involves.
okay. All right.
Thank you.
So you'll have 2 minutes, rebuttal.
Thank you.
Finger Lakes LPG.
Yes, Your Honor. Is it acceptable to Your Honor if we speak from the table, or would you prefer that we come up to the podium?
Podium.
Podium. Sorry.
I just want to be on TV.
My time started running yet?
No. That's 7 o'clock. So you have 20 minutes.
Right.
These are usually Circuit Court of Appeals podiums as opposed to the documents you need for an issues conference. Thank you, Your Honor. Good morning. Robert Alessi for the applicant. I think you've heard some remarkable statements already as to this whole issues conference and with regard to whether issues are adjudicable. To start with, Your Honor, gas-free Seneca said that community character is their greatest concern. I'm going to repeat that. Community character is their greatest concern, and you've heard from others who essentially made that statement. What you didn't hear, Your Honor, was the precedent, the true controlling precedent for community character. I will get to Chinese staff and why that case is completely inapposite for this proceeding. But you didn't hear anybody speak to the controlling precedent other than in passing of Crossroad Ventures, St. Lawrence Cement, and Red Wing, that community character is not adjudicable. It can't be any clearer. That precedent has been without a kink for 25 years. So this is not a legislative public hearing where people can speak to whatever issues they choose to speak to. Your Honor and the rest of us are guided by the rules, the regulations, and the precedent. We have put in our brief. We aren't going to elaborate because we don't believe it is necessary to elaborate on that point that community character is not an adjudicable issue. Remarkably, Gas-Free Seneca doesn't even mention St. Lawrence Cement in their brief. None of them hit this head on. None of them even try to say we think it's bad law and we think, you know, there's a basis for overturning it. They don't even say that. They ignore it. And they ignore it because it cannot be an adjudicable issue as a matter of law. It doesn't mean that community character isn't a relevant issue in terms of the overall application, but its relevance was answered in the scoping. And another error that the potential parties and amici make is they incorrectly cite the seeker regulations as about what is required in an EIS. And we cite that, Your Honor, in our brief because they say that, among others, that community character, cumulative impacts, they use the word must. And in 6 NYCRR 617.9, it is very, very clear that it says the draft EIS should identify and discuss the following only where applicable and significant. That decision was made in the scoping process as to what was to be addressed. But even though, and this is, Your Honor, the second bucket of where community character is addressed and how it is handled. It is addressed in two aspects. You'll note that in no petition before you has anybody spoken about, until Ms. Goldberg spoke about it and only cited part of it, where the character of underground storage facilities, how they exist in the state, how they are used, it's spoken to. And when you hear arguments today, and probably hereafter, about the sufficiency of the EIS, never do they go into the documents, the EISs upon which this STEIS is based. This STEIS alone is about 136 pages. The seeker regs say that EISs are supposed to be analytical, not encyclopedic, although this one borders on the encyclopedic. There's no reference to the other EISs upon which this is based that speak to many of the issues that you are going to hear in this issues conference. With regard to community character in Chinese staff, you heard a statement that Chinese staff is controlling precedent. That couldn't be further from the truth. Even a simple reading of Chinese staff, the issue was, where the displacement of the individuals, they called them then Chinese, but we now speak in terms of Asians, the Asian community were going to be displaced. Is that within the definition of an environment? That's what that case was about. The case was not about, is community character an adjudicable issue in a DEC proceeding? Moreover, it was on a negative declaration, whether the negative declaration could stand given that community character wasn't addressed. This is completely different from a situation where you have an EIS, where you have a scoping process, and it's determined what issues are to be addressed and what are to not be addressed. I want to now turn, before I get to the sort of substance of the community character issues, to some of the questions you asked, because I didn't necessarily hear answers to your question.
Can I ask you some questions
Yes.
first?
Oh, absolutely.
There is nothing in the draft SEIS about the community. I didn't see a section on community character at all in the draft. Did I miss it?
Your Honor, you did not see a section entitled Community Character.
Okay. And you said that it addressed community character in the sense of storage facilities. You mean the community character that it addressed was a community consisting of storage facilities? Was my understanding?
Your Honor, all of the EISs going back to 1988, 1992 talk about existing salt formations in communities, the fact that underground storage gas occurs. That is basically what exists in the community. In terms of community character, as the Commissioner's decisions made clear, community character for an issues conference consists of visual, noise, traffic, and then sometimes you can have odor. That's what an issues conference community character discussion is. All the other issues that you've heard are not appropriate for an issues conference. They could be appropriate for an EIS. We address in detail all of those particular issues. Also, in the EIS that we prepared, you will see environmental setting for each of the areas we go through. So while it is correct we don't put a label community character, the substance is there. And to address your question, what the petitioners have put into the record absolutely can form the basis of findings. There is case law that's endless. They're creating a record. This record is part of an FEIS, whether Your Honor's decision for an issues conference, response to comments. The department still has the ability to respond to these comments and therefore create a record. So the arguments that it's insufficient because there would be no basis upon which the findings, they themselves have added to the record, and the law is clear on that. So I wanted to address that.
Now, I don't think we've ever said that community character is per se unadjudicable. I mean, what cases like Crossroads Ventures and St. Lawrence say is it's often not amenable to adjudication, and generally it is addressed through things like visual, noise, et cetera, but I don't think we've unequivocally excluded it as a possibility. In fact, in St. Lawrence and in Crossroads, didn't we accept the comments of the party status petitioners as evidence of what the community character was? For example, in St. Lawrence, the dispute was between whether or not the community character was of an industrial use versus a more bucolic recreational tourist use. And in St. Lawrence, we accepted that view, that other view of the region as part of the issues ruling, the second interim decision.
Judge,
in other words, we essentially allowed for the development of the record on what in fact was the community character.
Your Honor, I have the same reading of St. Lawrence Cement. I was the attorney for St. Lawrence Cement.
I recall that.
So I recall the discussion. But what has never happened is the department has never said, certainly not in the last 25 years, that community character is an adjudicable issue. You can, and I frankly believe should, accept what has been stated in the petitions as part of the record that ultimately gets looked at in terms of the secret balancing and other issues. That is fine. But what you heard today is something much different, is that community character is our greatest concern and it must be adjudicated. It is a substantive and significant issue. St. Lawrence, Crossroads are incontrovertibly clear that they can't be adjudicable issues. Now, is it true in an absolute sense? I don't have a case that says it will never, but there is no case, especially on the issues that are spoken about here, that says it's an adjudicable issue. So that's why I put it in two buckets, Your Honor. I put the one bucket for what can be adjudicated, and the other bucket is what can be put into the record to make the ultimate decisions. We're okay with the latter, but certainly not the former, and we think that the precedent is there, and Chinese staff does not help that.
Well, what Chinese staff, at least as I understand it, it would require the department to look at impacts. Well, it's difficult to get your hands around Chinese staff, but Chinese staff, the question was a new use coming into a neighborhood, and did the agency have to look at that? I think they have a similar argument here. They're saying this is an industrial use coming into what is basically an agricultural environment. Not only an agricultural one, but one that has been developed as a unique Finger Lakes wine country type of character.
Your Honor,
So don't we need to consider that, the potential impacts of this on that character of the community?
Your Honor, a couple of points. With regard to the community, you were asking questions about how far away can we go for that. We have two documents, and I think you might have got an answer, does Town of Reading have a comprehensive plan? The answer was no. The answer is yes. It's right online. It's a 1991 comprehensive plan. I have it with me here today. So I just wanted to dispel that incorrect statement. We also have the Schuyler County Comprehensive.
That plan, though, hasn't, is that in any of the materials that have been submitted?
It's not, but Your Honor could take official notice of it, given it the nature of the document. We also have the Schuyler County County-wide Comprehensive Plan, May 2014. There's a whole section on the Town of Reading.
Also not currently in the record.
Well, we cited to it in our brief, and you can take official notice of it.
But it wasn't submitted.
It wasn't submitted, that's correct. Page 68 talks about the Town of Reading, and it has a different view than what you heard today about the community and the industrial nature and the importance of industry to the community, et cetera. So I wanted to correct the record on that.
Those plans were taken into account the DEIS.
They couldn't be because the DEIS was 2011, and the comprehensive plan is 2014.
That would be difficult.
That would be more challenging for us. I just wanted to address comprehensive staff. Chinese staff. Chinese staff was an issue of a negative declaration. That is a far different consideration because we had scoping here. Because in the neg deck you don't have scoping, but here we had scoping. And there was a determination as to what was important and what was not important. And more importantly, as we go through this process, we have established it. So again, I think it's important to keep
During
it two buckets.
scoping, did any members of the community raise the
Yes.
Finger Lakes wine business
Absolutely.
or country as a potential community character?
Absolutely.
And how was that addressed then?
It was not deemed to be an issue that needed to be per se, and I can't tell you from complete memory, but because visual, traffic, and noise, and looking at the precedent, everybody considered that would be the way community character would be addressed.
Now, presumably staff made that determination, right?
No, absolutely, staff makes that determination.
So staff made a determination it was not necessarily to, as part of the environmental setting of this project, include at least some reference to this burgeoning wine industry in the area.
Well, the answer is certainly with regard to this burgeoning wine industry, there's a proximity issue here. And, you know, they're entitled to proximity, meaning how far away in terms of distance. But in terms
Well,
of...
how near is the nearest vineyard or winery?
I think one might be like a mile or a little over a mile away, but most of them are far in excess. But, Your Honor, the point is here is this isn't the issue of whether it's adjudicable, I think, is clear. The other issue is the record sufficient upon which to make seeker findings? And I think they've cured that, even if there was ever an issue on that. And Your Honor, you had also asked questions.
They cured it by, I mean, the submissions have been made.
Exactly. And you asked for the authority for, you know, and you've got Village of Chestnut Ridge, and Your Honor, that is not authority for their proposition for an adjudicable issue. So, in conclusion, Your Honor, with regard to the community character issue, they have stated that it is their greatest concern, and you can see that all through the papers. And while we understand they view that as their greatest concern, and we respect the fact that they have a concern, this issues conference process is not for whether something is a greatest concern. It's whether there's a substantive and significant issue, and there is precedent that deals with that. And the question about, there's no doubt that community character is in the definition of environment. But that gets addressed, and there are legions of decisions of the commissioner that say that not all concerns get addressed in an issues conference, or excuse me, adjudicatory hearing. There's response to comments, and the department should be given the opportunity to respond to these comments to create a further record. That's the way the process works. So in conclusion, Your Honor, while we respect the concern with regard to community character, the procedures here are very clear and the precedent is very clear, and we can continue to develop the record on that issue as the secret process goes forward.
So you would have no objection then to basically taking all the various submissions and reports and whatnot that the petitioners have generated on community character, simply allow that into the record and allow that to be the basis for argument and on community character impacts, and then ultimately a record upon which the commissioner can make secret findings. You're not going to object to that, is that my understanding?
Your Honor, just so I'm clear, when you talk about the record, we would object to that being part of the issues conference record upon which a determination is made as to whether the issue is adjudicable, because we think it's out of scope. We do agree that, and we welcome the information for part of the overall seeker record, which is different from an adjudicatory hearing issue. We welcome that information in terms of developing the record so that when the commissioner does the balancing, ultimately, social, economic, and environmental, that information is available to the commissioner to balance those three out. And we want to participate in the response to comments in contributing further information through the seeker process, not an issues conference, through the seeker process to contribute to the development.
Well, right. Well, the way that would play out then would be we would accept these reports in, and then I guess there would be briefing, and that would be the opportunity then to make argument about whether or not the commissioner can make secret findings vis-a-vis community character. That would be the response to comments and in this process, and then it would be addressed in issues ruling and any final decision of the commissioner.
Your Honor, first the commissioner has to...
I think that was what was contemplated, but of course we didn't get to the end of the road in St. Lawrence, but I believe that's what was contemplated there.
Your Honor, I have the same sense of what was contemplated. However, I will say two things. I want to underscore your statement about argument. They can make further argument with regard to what's already in the record, but not submit additional proof. I heard your questioning with one of the amici on that, because that information can go in from an amici for the record we just talked about, but not for determining whether an issue is adjudicable. Lastly, with regard to what you're talking about...
Well, I mean, whether or not issue is adjudicable, I mean, what do you mean? I mean, the question is, do we have to have a fact hearing on this to develop the record on community character? If not, then we simply take the materials that have been submitted and then legal argument on the issue of the impacts on community character for purposes of secret findings by the commissioner.
Agreed.
The two right. Because when you say whether or not issue is adjudicable or not, I think we need to be clear. Are we talking about whether or not we're going to actually try fact issues, or are we simply going to resolve the legal issues?
I agree with your distinction with regard to that, Your Honor, and with regard to the other part of your question on community character, the commissioner also will make a determination about whether community character as a label had to be in the DEIS, which is a whole other issue that we've talked about, because the scoping process has to have some meaning. We submit that visual, traffic, noise are the essence for commissioner decisions of...
But if the commissioner concludes that the record was not complete on community character, is the commissioner prohibited because of scoping from considering the documents that have been supplied by the petitioners?
Your Honor, according to the DEC's own regulations, for an issue, and to answer your question, that was scoped and it was not put per se in scope, there's a procedure for parties who believe that it should be considered in the DEIS. These parties didn't follow that procedure. They had the opportunity...
We have a hearing procedure now?
We do have a hearing procedure.
Isn't part of the purpose of the adjudicatory proceeding is to complete the secret record for purposes of... I mean, the ultimate hearing report of the administrative law judge is the final EIS in a proceeding where the department is the lead agency. So are we using procedure to complete the secret record here?
You're absolutely correct, Your Honor.
Do you think it should be prohibited from adding an issue because of scoping?
Well, prohibited adding an adjudicatory issue, Your Honor, yes. However, he's not prohibited from saying that this is going to be part of my consideration in making findings with regard to the matter. But again, Your Honor, the key point here is, with regard to the record, the petitioners have added to the record on community character. I find it very difficult, given all the submissions, how the commissioner could come to a conclusion that with what they've put in would be an insufficient record, but of course that's your determination and that's the commissioner's determination. I just wanted to keep separate the adjudicatory aspect of it. We didn't get to visual, which we had. We're going to reserve that for another part, because community character has, as Your Honor knows, visual, traffic, noise, etc. And we just wanted to provide some information to Your Honor. Your Honor, just to conclude here, community character is not adjudicable. We understand that Your Honor certainly has the authority to take further briefing argument on that particular issue, but with regard to offers of proof, that is sealed. We believe the law is very clear and there's no basis for overturning the precedent, and we support and respect the seeker process. And again, the petitioners adding to the record, as they've done today, for the commissioner to issue his findings, and the commissioner can look at community character and make his own decision as to whether it's sufficient, as can and will Your Honor. So thank you very much for the opportunity to present.
Thank you.
Judge, can I just add, since there's really no place to discuss visual elsewhere in the schedule, the only thing I would add is that as part of community character, we have a visual impact assessment that's in the record, hearing document 1D35.
Can't hear you. We can't hear you.
Hey, you hear me, she hears me, that's fine. We've done the only visual impact assessment that's in the record. There are profiles, pictures. They clearly demonstrate that there's a lack of visual impact on neighboring communities, particularly across the lake, from which you cannot see, very much on the site currently, and will not be able to see anything.
Well, should we add visual impacts to the list of issues discussed? I mean, we probably will have time tomorrow.
You didn't have much to add on that. We do have Mr. Luzo to show you some shots from the visual impact analysis. Nothing really new, but he could at least demonstrate how the methodology that he utilized and the conclusions that he reached using pictures to demonstrate no visual impact. So we can do that if you'd like.
Are the parties interested in making a presentation on visual impacts?
Your Honor, the staff is prepared to address visual impacts. So if the applicant is going to address it, then we will follow up on it.
Well, there were parties, weren't there, that objected to the visual impact analysis? I believe I think there was something in the petition, as I recall.
There may have been references, but it wasn't raised as a separate adjudicable issue. It was really raised in the context of community character. If staff is going to address it in their presentation, perhaps they'll cover the points that we intended to cover anyway. And if that's the case, we'll let you know, and therefore we don't have to have a separate kind of session or calendar session on visual. Is that okay?
Sure. Well, again, let me just make sure. Did any of the party petitioners want to make any argument about visual impact?
Your Honor, it seems rather unorthodox that the applicant is now introducing a new issue into this proceeding without notice to any of the other petitioners for party status. We did not raise it, and the other parties raised it. I've just admitted there's nothing new in these materials. We are not prepared. As a result, we've not focused.
Well, again, I think one of the petitions there was some discussion, and maybe in the context of community character, that there were visual impacts that were not taken into account. Was that in your petition?
Yes, there's certainly there's definitely visual. The view shed and visual impact is part of the community character analysis. Our expert did address that. We do a photo in this thing as well of the view from Heaven Falls.
And you don't want to make any presentation on that at this point?
I don't really see, given the limitations of the time right now, that...
Well, as I say, I think we could add it as an issue tomorrow if you want to make a presentation on your petition. It's up to you all. I feel that if petitioner didn't want to specifically focus on it, then I don't see there's any need to respond to it at this point. We can deal with it in briefing if we end up having that in this case.
The Well, the only thing I would say is I certainly am not raising it as an issue. The furthest thing from I will come out. So I wanted to correct the record, at least what you said. That's not what I'm suggesting. What I'm suggesting is that whatever comments that you may have made in your petitions have no basis in fact or reality. I think that our visual impact assessment reflects that, and that's really all I have to say. I don't know if you want to add anything.
Well, your time is up, so I don't
The time is up by about 3 minutes already, and I would ask that we get some additional time for rebuttal, given the additional time that's just been granted to the applicant.
all right, we'll add a minute.
Your Honor, my procedural, our suggestion is staff goes, they speak to visual, we hear what they have to say. If we don't have anything meaningful more to add, then we would just say, we're done.
Right, okay.
Right.
I just want everybody to be happy. Or not. All right, so Department of Environmental Conservation, I've given you 10 minutes.
Your Honor, Lawrence Weintraub for the staff of the Department of Environmental Conservation. On the larger issue of community character, the staff wishes to reserve taking a position until briefing. And so...
Well, can I ask you, how was it that impacts on the Finger Lakes wine country wasn't deemed to be something that needed to be included in the EIS?
Well, all I can say, Your Honor, is that there was a lengthy scoping process, and there were scoping hearings. There was a public comment period. There was a draft scope that was put out, and a final scope, and it was not. There were some comments made about community character in the comments, but it did not end up in the scope.
I mean, I went to the I Love New York site, which I believe is a state site. You've got the Seneca Lake Wine Trail there, the Cayuga Lake Wine Trail. I mean, this seems to be of significance, at least to state tourism.
Right.
And I understand that there were comments raised about the wine country, Finger Lakes wine country.
There were a few comments in the scoping process on the Finger Lakes Wine Trail. Not a lot, but a few comments. But it was a scoping process, and the purpose of scoping is to set, to establish the issues that would be studied.
Right.
And scoping does, scoping. It's not as if an issue can't be raised after scoping, but we do scoping so we can give the applicant fair notice what it has to study and put it in DEIS.
But you can't tell me why it is that it was decided not to include the wine industry in the environmental setting of this EIS.
Why it was specifically not included in the scope,
Yeah.
I can't recall that. I will say one other thing, that secret is an iterative process, and there's plenty of case law on that, and issues can be iterated even after the DEIS is accepted, so it may not be that important because the issue obviously has that it wasn't specifically put in as an issue of community character in the DEIS, because obviously it's being iterated very much right now.
So you wouldn't prohibit the commissioner from looking at the Finger Lakes wine country because it wasn't included in the scope?
No, but I would qualify my statement by saying that right now the staff wishes to reserve on this issue.
All right. What if we have no briefing?
Well, hopefully we will request briefing.
All right.
Staff will request briefing. That, as Mr. Alessi mentioned, community character has its component issues of visual, noise, odor, and truck traffic. It appears that I'm not clear whether visual is being raised or not being raised as an issue to adjudication. There was no expert reports that were filed in the submissions on visual. So what stands, the record stands, as the record stands, we have a visual impact analysis we have a whole section of DEIS that's dedicated to visual impact analysis. And we have, and the staff has made conclusions based on that, and the conclusion is for purposes of this issues conference is that there are no substantive and significant issues with regard to visual impact. The substantive conclusion is that the site would look pretty much, the view sheds from 414, which is the scenic byway on the other side of the lake, and 14 and 14A would appear pretty much as it does now after mitigation is applied, and the visual impact analysis provides for mitigation. And that would be included as a condition of the permit. There is screening mitigation and there is lighting mitigation provided in the visual impact report. We have, I have with me Dave Denver, who is the regional permit administrator for Region 7. He did the hands-on evaluation of the applicant's visual analysis report. He also did early on a visual analysis of his own on this project. And he's just going to talk about the fact that the visual analysis complies with the scoping, with the visual policy of the Division of Environmental Permits. And
well, I did say that I wasn't going to have experts making presentations
Okay.
at this issues conference, so
Okay.
I don't think it would be appropriate to take that course at this point.
Okay, so I'll just conclude that the visual impact study does comply with our visual policy, and substantively, as I said, that the view shed would be pretty much as it is right now after the mitigation is applied. The petitioning parties raise a question about Hector Falls and the impact of the project on the view shed from Hector Falls. I'd like to note that Hector Falls is not a receptor under the visual policy, but there are receptor points above and below Hector Point, and I've already stated what the analysis shows. And finally, and they also raise an issue with regard to a flare, and again, the staff have concluded that there are no substantive and significant issues with regard to the operation of that flare on the brine pond. How much time do we have left?
3 minutes, 3.5 minutes.
We do want to just hit, staff wants to just hit on the traffic issue. Again, I'm not clear as if the petitioning parties are raising it as an adjudicable issue. They're certainly mentioning it in their report, so so the staff is just going to hit on it briefly, and I'd like to bring on Lisa Schwartz, Assistant Regional Attorney, to discuss that.
Your Honor, hi. I just want to address the truck traffic, or I mean, just a highlight, because it's really all been said and it's all on the record. We don't think that the truck traffic is an adjudicable issue. We also don't think the rail traffic is an adjudicable issue either. On the rail traffic, we're preempted. It's a federal issue, and under the, get this right, Federal Surface Transportation Act. So everything that goes on with the rail off the site, we're preempted. That's why
truck traffic, my understanding
truck
is
traffic,
they're not planning on using trucks, right? They're only going to use rail and pipeline?
So the highlight on that, Your Honor, is that the current plan is that they're not going to even use the trucks. But the
Is there a
DEIS...
condition that would
No.
prohibit use of trucks?
No.
Why not?
Because I asked about whether or not they'd want to just take the truck facility out altogether, and they did not want to. So I consider what the DEIS, it's there in case it's needed.
So then
in case
we have to
there's
consider-
particularly bad winter, et cetera, et cetera. So,
Since it's not allowed then, I mean, since it's not being prohibited then in the permit, then
It's
we
not
have to
being
consider the
prohibited.
potential impacts in the event they do use trucks.
yes, yes. So then, what that leaves us with is the DEIS does analyze that, and adequately and well. And we can consider it a worst-case analysis. And going to that, my highlight on that is that I think that we wrap up with the DOT letter that came in on January 11th, 2012. And that is at document list Roman numeral 1I, B4, and also Roman numeral 1B6, attachment 9, because we put it in two places. That's the letter that states that the DOT has concluded that the traffic impacts associated with the proposed action do not represent a substantial increase to the existing traffic volumes, nor do they present a need for mitigation to the highway. Right? That's DOT, that's the agency with jurisdiction, that's what they had to say. And that's what the worst case scenario. I'd also like to say that the department staff did a little analysis of their own, not that we don't trust DOT, but went over to the DOT website, looked at some of their data, looked at some of the data in the DEIS, and doing our analysis, determined that on routes 14 and 14A, the increase in truck traffic would be no more at any point than 1.2%. The increase, no more than 1.2%. And that's what we have to say about it.
It's a good one, we're ready.
And yet I'm done.
Okay. Would you have, is that documented?
Oh, I would, there is one more thing I'd like to,
Is it the DEC own analysis, where is that documented? Do you have the document number for that?
I don't have a document on that, Your Honor. I just, if we would have, we would put it in our comments, in our response to comments when we finish the FEIS. We would have done that before, and now we'll do it, I think, in the future.
But otherwise it's not documented.
No, that's why I thought it would be good to say something now.
Okay.
I did have one more thing, Your Honor, that's not entirely on my whatever. I wasn't positive from what you sent around that we would not be able to use any of our people to talk for a minute within our allotted time. Is that, is that, you're wedded to that?
Yeah, I really felt like this needs, where this is basically oral argument on whether or not we have adjudicable issues to try and to hear argument on the legal issues. I didn't want to have experts testify.
I do understand about the testify.
It's not an appropriate place to have testimony.
We were, I would agree with Ms. Schwartz. We were of the understanding, particularly when it got to the more scientific and political issues, that perhaps we'll discuss this afternoon, for example, that we would incorporate it within our time frame, not in any additional time.
I thought I was pretty clear in telephone conferences before this, in email communications, that I did not want to hear from experts. I don't want to have a issues conference where we're basically taking direct testimony of the analysts. The purpose of this is to determine whether or not we have trial issues of fact or not, and if not, then hear legal argument. So that was my expectation. I thought I was pretty clear about it.
Your Honor, you were entirely clear about that, and on behalf of the Seneca Lake communities, we're not prepared to have you take testimony from our experts at this point, based on what we thought was your very clear directive, that this was a forum for legal argument only.
Well, again, just to be clear, our experts are here and they weren't going to testify on the oath or anything. All they were going to do was summarize and or present some of their responses.
Yeah, but if they're up there doing theirs, that they're essentially testifying, aren't they? On the record?
Judge, if I could be heard on that. The issues conference, as you know, operates such that petitions come in, and in the ordinary course, there would not be any responses of the applicant or the department. There would be none. They would come into the issues conference and speak to the issues, and under 624.4 B2 and B3 is actually B2 in determining whether there's a substantive significant issue. The ALJ may consider the proposed issue in light of the application and related documents, the draft permit, the content of any petitions filed for party status, the record of the issues conference. If in the ordinary course you don't even have a response, how is it then that the applicant can come in and only be limited to argument? In most issues conferences, you do come in, you do provide technical information. Sometimes the experts do speak with regard to the matter. We certainly don't want a Crossroads Ventures matter where we end up spilling into an adjudicatory hearing with oath, but the question would be, how would you, in the absence of a response, how would you ever put in some of that information if you're limited to attorneys making an argument? And I apologize, I didn't understand, and I might have missed it, with regard to that the applicant in the department was not going to be able to have people speak to why the issues aren't substantive and significant. It's to resolve factual dispute, as Your Honor said earlier today, and you resolve factual dispute at issues conferences sometimes by having the experts speak to factual issues with regard to the matter. So I apologize if I misunderstood. I don't recall an email or a statement to that regard, but I'm trying to understand, if we would put in a response, how would the record be developed with regard to these factual issues if only the attorneys could speak to the issues?
Your Honor, we very explicitly raised this question because we really weren't sure. It was discussed on the telephone. And I believe the 200 pages or whatever this is of response that we received on Monday night would provide exactly the opportunity that the applicant would need and that we could consider so that we would all have a little argument here today. None of the petitioners here are prepared to be putting on experts. We understood that would be inappropriate, and we would be very much prejudiced if their experts were heard today.
Anybody else want to be heard on this issue? All right, it's, interesting you raised Crossroads Ventures, and of course the department has been criticized for the way that issues conference was conducted. And my understanding of the issues conference, and maybe if you had a different ALJ, you'd get a different understanding of it. But my understanding of the issues conference is it's like summary judgment. It's not for presentation of evidence, it's to make argument about whether or not there are tribal issues of fact or not. And if not, then to hear argument on the legal issues. So that was what I contemplated this was going to be today, and I thought I made it clear. So how would you rebut the attempt to show that there's a tribal issue of fact? It would be the way you would do it on a summary judgment motion. I don't think we have to take, in a civil judicial proceeding, I don't think a judge would allow an opponent to summary judgment to allow a witness to come up and testify at the hearing, now would they?
Your Honor,
on the motion.
Your analogy to a summary judgment motion, I understand. I'm not so sure I go that far with the analogy because for example, the energy decision, which is in our brief, talks about the ability of the department to rebut factual and scientific information. And my question is, my point is, Your Honor, this is different than a summary judgment motion because, again, the way the procedures go, as you know, is the petitioners you see for the very first time in a petition for party status, expert reports. That's the very first time you see what the other side has to say. If you're just limited, and in the ordinary course there's no response, Your Honor put in a notice clearly that we didn't even have to respond to what was in the notice. My question would be, if it's summary judgment completely analogous to, there would never be an opportunity, unless Your Honor, who graciously granted the ability to respond, there'd be no opportunity to put in that fact.
Well, that was part of the reason why we had the written responses, and you took advantage of that, and in fact, I believe you submitted some reports of your own experts to try to rebut the factual showings of the petitioners. So
And
looks like it worked to me.
But Your Honor also put in that very notice, right, that we didn't have to do it, and it was without prejudice to us coming to the issues conference and making presentations. The department can speak for itself, Your Honor. We're very, very comfortable with what we put in with regard to the information on the issues. But the department can speak for itself, but where's the opportunity for the department to have their folks speak with regard to cavern integrity? Because they didn't respond. We all understood it was optional whether we did. So we're okay with regard to, if Your Honor's decision is the applicant, you're limited to argument, we'll accept that. We think the law is a little different, but we'll accept it. But with regard to the department that had to make a choice, are they going to respond or not, we think that would be a rather unfortunate situation for their folks to talk about.
Well, I think the department can speak for itself as to on this issue. Does the department feel it's going to be prejudiced at this point?
No.
All right. Thank you. All right, so we have some rebuttal time reserved. Should we go ahead and proceed on that now, and then we'll take a break after the rebuttal? So I've added a minute to your time.
Thank you.
With the
permission of the other petitioner, I will take that extra minute. So I would like to address, if I can, in my 3 minutes, 3 points, all that were raised by Your Honor during the course of the questioning. The first question is whether there is any case law saying that you legally cannot adjudicate community character. And the case cited, the principal case cited, was St. Lawrence Cement for that proposition. St. Lawrence Cement, DEIS, covered the trend away from industrial uses and towards greater reliance on recreation and tourism. That's a quote, 2004 Westlaw 202-6420, *50. Here, the DSIS has no discussion of community character, no discussion of land use and recreation, no socioeconomic study. Moreover, in St. Lawrence Cement, the applicant did not contest that local trends could affect the Hudson Valley community. Here, the applicant is denying that there's any local trend away from heavy industrial uses. And that alone, Your Honor, is a factual issue that ought to be adjudicated. Chinese staff states, and I quote, "The impact that a project may have on existing community character, with or without a separate impact on physical environment, is a relevant concern in an environmental analysis, since the statute includes these concerns as elements of the environment." There is no basis that I know of in the law for treating community concern differently than all of the other relevant areas of environmental concern. All of those issues, if there are disputed issues of fact, and I just named one, are adjudicable in this proceeding. Second, Your Honor, you asked whether there were comments made about community character and scoping, and the applicant admitted that there were. He also pointed you to procedures that are supposed to be accommodate the fact that they failed to include community character in the scoping. The only procedures I was able to identify cover when an issue is raised after the scoping for the first time, and there's new information coming in. There's a procedure for that. There's no question. But in this case, it was raised before the scoping, and it was rejected, as far as we can tell, without any explanation whatsoever. The positive declaration in the record has no explanation of why they failed to mention or identify community character as significant, no explanation of why they failed to identify land use changes or the effect on recreation as insignificant, no mention of why the socioeconomic impacts would be considered insignificant. So again, Your Honor, I will mention that when we were retained in 2013, we did send a written letter to DEC asking that they consider community character. There has been ample time since then to do so or to ask the applicant to do so. They have not done so. That now presents a very serious adjudicable issue. And the third factual issue.
That's 3 minutes.
That's 3? Oh. Okay.
Thank you. And Finger Lakes Wine Business reserved 2 minutes.
Yes, Your Honor. If we could have an additional minute as well, that would be appreciated.
On what basis?
Well, the applicant was given a substantial amount of additional time. We were not given a total of 3 minutes amongst the groups. It was my understanding when you said 1 minute, I thought it was 1 minute for each
All
of
right,
us.
I'll give you 3 minutes. So this is 3 minutes.
And I will try and be as quick as possible.
Please.
On the issue of community character and the obligation, we would say for you to review that issue, I would just point you to ECL 801056, defining environment as the physical conditions which will be affected by proposed action, including existing patterns of population concentration, distribution or growth, and existing community or character. It's in the statute, Your Honor, as a separate criteria in examining the environment. It is for the legislature to remove that from the statute if it is going to be removed from your consideration or review. We would also submit that the case law is clear that community character can be a region. In Walmart stores versus North Elba, they looked at the region of the Adirondacks in considering whether or not a Walmart store affected the community character. We would submit that there is a picture, Your Honor, in the record, Exhibit B, which identifies the wineries and shows that the entire region is taken up by the Finger Lakes wineries and their impact in this community. As far as our ability to present information to you, we would submit that we're obligated under the statute to show you what our environmental interest is. And we have tried to do so by demonstrating both the location of the wineries and the interest that our members have shown. As far as the scoping session, our members were present at the scoping session. They did distinctly raise the interest of the Finger Lakes wineries in the impact of this facility and the impact upon the community character for their interests. That the department has chosen not to make that an issue is the very reason that we're here. As far as the factual discussion that we're having, I think that that demonstrates that this is in fact suited to the adjudicatory hearing. That's the time to resolve factual disputes. As Your Honor correctly pointed out, this is the time for legal argument. Our legal argument would be that this issue is worthy of adjudication, it requires an adjudication, and that our members have a voice that will provide valuable input to you in considering that issue for adjudication. We would submit that you should in fact consider community character and that we should have an opportunity for our voice to be heard in that regard. Thank you very much.
Thank you. So that concludes community character. Before we move on to the public safety issues, I propose that we take a 10-minute break. That's going to put us a little behind schedule, but I don't think we want to go soldier right through, do we? All right, so let's take a 10-minute break.
Thank you, Your Honor.